The 11th Circuit kind of went the opposite way in Garcia-Simisterra v. U.S. Attorney General on December 30th. And they essentially said that even when a non-citizen, it seems, pleads down to avoid the $10,000 amount, so they probably have pled to avoid immigration consequences, even when that happens, the board and IJ and the 11th Circuit can use the circumstance-specific approach to look at everything and to look at the indictment and to look at what was charged, even though that wasn't pled to. So they charged him with like a $200,000 conspiracy or whatever it was, but he pled to, $8,000. And the 11th Circuit says it doesn't matter because in order for this charge to be sustained, it's very clear that there was a humongous loss, even though he only pled to an $8,000 loss, something like that. Again, I talk about it much more on the podcast where in the week that it was published. But that's the 11th Circuit going in the opposite direction, saying we can look at everything. We don't care what you pled to. So Garcia-Simisterra, if people are playing in this world, to me really highlights that if you're going to plead down for immigration consequences, at least where the circumstance-specific approach applies, and it applies at 101A43MI and a lot of other removal offenses, you have to be really specific. You need a plea agreement that's really clear that that's the entire universe of facts. Maybe you need the prosecutor to draft up an entire new indictment. I don't know. Again, that's in the 11th Circuit, and so that's a smaller circuit. It does hit home though, because that is where the Kurzban firm, where I'm a partner, is based.